going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. This is Judge O'Donnell, also known as Judge Spicy, and he is, well, let's just say we have a defendant with attitude. I'm going to say a lot of attitude, and it's not about what he's, the energy he's bringing. It's about what he says, and he's not yelling, but plenty of attitude coming out of this defendant. All right, let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
The defendant is present today in court with counsel, Mr. Mulkey. We're here for purposes of a change of plea. It is the state's understanding that today the defendant is desirous of withdrawing a formally entered plea of not guilty and pleading guilty to those charges as outlined in the indictment. And the matter will be referred to the Lake County Adult Probation Department for a pre-sentence report and any other reports the defense feels are appropriate in the matter.
Okay. Mr. Mulkey?
Thank you, Judge. Yes, that is all accurate. It's my understanding my client will be entering a plea today as outlined by the state to this matter. Thank you.
Is that your intention, Mr. Green?
Right.
Okay, how old are you?
34.
How far did you go through school?
Right, I completed school.
Are you a U.S. citizen?
Correct.
Are you able to read, write, and understand the English language?
Right.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of this indictment?
No, I have not get a copy of it.
The charges? You didn't get a copy of the charges?
I have some previous paperwork, but I haven't had today's copy.
Okay, but you've gotten it in the past, right?
All right.
Right?
Right.
Okay. All right, now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, then stop me. If you want more time to talk to Mr. Mulkey, let me know and I'll give you more time. You understand that?
All right.
All right, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Right.
Are you waiving that right?
Right.
If you go to a jury trial, the prosecutor, if you go to a jury trial, the jury must find you guilty beyond a reasonable doubt before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor is going to call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Right.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Right.
Are you waiving that right?
Right.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Right.
Are you waiving that right?
Yes.
All right, if those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Right.
Are you waiving that right?
Right.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you don't want to. Do you understand that right?
Yes.
Are you waiving that right?
Right.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Right.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Right.
Are you waiving that right?
Right.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Right.
Are you waiving that right?
Right.
If you couldn't afford to hire a lawyer, one would be given to you at no cost. Do you understand that?
Right.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Right.
Are you waiving that right?
Right.
If you can't afford a copy of those transcripts, they'd be given to you at no charge. Do you understand that?
Yes.
If you plead guilty today, you don't have the right to appeal the guilty finding. Do you understand that?
Right.
Do you have any questions about any of those rights?
So, and my sentencing date will be within a few weeks?
Yeah.
All right.
Okay. No question about your rights that I read to you?
No, I waived them.
All right. You still want to plead guilty to these two charges?
Right.
Do you understand that by pleading guilty, you're fully admitting your guilt to the charges?
Right.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control.
Right.
All right, now, count one, strangulation is a felony of the third degree. It carries a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
Right.
And assault is a felony of the fourth degree. In count two, it carries an 18-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Right.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 54 months and a maximum fine of $12,500. Do you understand that?
Right.
Are you on post-release control to the parole authority right now?
No.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
No, I do not.
Okay, well, if you're convicted of this, if you plead guilty to this, to these charges, then you're prevented from owning a firearm. Do you understand that?
Right.
Okay. Do you understand that if I send you to prison, that when you get out, you will be on post-release control for at least a year, up to 3 years under the parole authority?
Right.
They'll put conditions on you. If you violate their conditions, they could send you back to prison on this sentence for up to 9 months for each violation, up to 1/2 of the sentence I give you. Do you understand that?
Right.
If that violation of post-release control is a new felony, then in addition to being prosecuted for that case, you could get an additional consecutive prison sentence for this violation. Do you understand that?
Right.
If I gave you an additional consecutive sentence for a post-release control violation, the maximum prison term you could get for that would be either 12 months or the time left under post-release control, whichever is more. Do you understand that?
Right.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Right.
All right, I could put you on community control for up to 5 years, but if you violate any conditions, then I could send you to prison for 54 months. Do you understand that?
No, I was seeking probation. I don't know.
Right, if I gave you probation and then I found you violated, then you could go to prison for 54 months. Do you understand that?
Right.
Okay. Now, is anybody promised lenient on you pleading guilty? As what I would in this case.
54 months.
Well, has anybody what I would sentence? And sentencing, the recommendation for sentence, your lawyer may make a recommendation for sentence. Do you understand? I don't have to follow either of those recommendations.
Right.
Now, have you had enough time to talk with Mr. Mulkey before pleading guilty today?
Right.
Has he discussed everything about your case and answered all of your questions?
Right.
Are you satisfied with the advice he has given you?
Right.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Right.
Do you have any questions at this point?
Now, sentencing, date within a few weeks, right?
It'll be January 15th. 4 weeks. Do you have any other questions?
No.
What?
Judge, I
What?
made a mistake
What?
in the paperwork, I'm sorry.
What?
The assault is a felony 5, but when I filled in the amount of time he faces,
Oh.
I put it for the 4, so it's really 6 to 12 months, and he faces a maximum 48 months.
Okay,
I'm sorry, Judge.
it's okay. I should have caught that.
And it's per the indictment too, Your Honor.
Right.
So the indictment's-
All right, so let's go back a little bit, Mr. Green. I told you that assault was a felony of the 4th degree, but it's a felony of the 5th degree. You understand that? It's less than what I said it was before.
Right.
Okay, so the
Still.
penalty on that, the most you can get on that is 12 months in prison instead of 18. Do you understand that? I told you before it was 18, but it's actually 12.
Okay.
All right? And so then, when I told you about a consecutive sentence, if I gave you a consecutive sentence, the most you could get would be 48 months in prison instead of the 54 I told you. Do you understand that?
Now I do.
Okay. All right. Anything else?
No, Judge.
All right. Ms. Naroda, if the case went to trial, what would this evidence show?
Judge, had the state proceeded to trial in this matter, they would have brought forth the following facts that support the charges in count 1 and 2. And that was on May 28th of 2024 in Painesville, Lake County, Ohio. Otis Green was in the Lake County Jail. He was in the classification range on the first floor. And it was dinner time when Officer Lehman began serving dinner to Mr. Green and another inmate. When Officer Lehman had the cell door to Mr. Green's cell open, Mr. Green wanted to exit and change the TV channel, and the corrections officer did not want that to happen, so there was physical combat at that point. And once Mr. Green and the CO got back into the cell, Mr. Green placed his hands on the face and neck area of the CO, causing red marks and scratches, and temporarily affected the CO's ability to breathe at that time, because he was angry that he couldn't go out and change the channel.
Okay. Mr. Mulkey, anything to add to those facts?
Nothing, Your Honor, thank you.
All right, Mr. Green, did you hear what Ms. Naroda said the facts would show if witnesses came in here and testified at a trial?
I heard what she had to say, but I have an objection. That's not what happened, if I can explain my side of the story again. Did you want to hear it? Right. The correctional officer was serving supper chow. He let somebody else out during my hour out. They get to have multiple hours out on my floor or whatever. But he knocked my styro plate, and I'm real fed up with them serving me that type way, out of my hand, pushed me in my cell, and got into it with me. So, in self-defense, I was protecting myself. The officer was talking about some kneel down or gay comments and slurs. So I wasn't taking it. He knocked my food out of my hand, banana, and then they put me in a restraint chair or whatever. I do not agree with what's going on. That's all I have to say.
Yeah, that sounds like he's not guilty. You know, self-defense is absolutely a defense to assault. And you have a defense, so why are you taking this plea deal? Just saying. It might be difficult for an inmate to win a legal battle against a correctional officer. It doesn't mean you don't try. I mean, especially if you're not guilty. We have all that attitude. Well, now I know why he's upset. He's being told to take a plea deal, apparently. Calm down, Heather. All right, let's go.
I have a moment with my client, Your Honor.
Yeah, why don't we give him some time by himself?
All rise.
Mr. Mulkey?
Thank you, Your Honor. May it please the court and the counsel. After a detailed discussion regarding trial tactics, strategy, and should that be an option for him, I went through those options and issues with my client, Your Honor. He mentioned here in court on the record something to the notion of self-defense. I explained to him what the legal connotations of that, presentation of evidence to support that potentially and all of that. And after that discussion, without going into its contents, Your Honor, he would like to go forward with his change of plea today and not raise a self-defense claim at this time, Your Honor. Thank you.
Is that correct, Mr. Green?
That's what me and Chad T. Markey just said.
I know, but is that correct?
That's what we just said.
I heard him say it, but that's not my question. My question is that correct? Are you claiming self-defense in this thing?
Right.
Is that yes?
That's what I just said.
Well, you said right. So you don't want to plead guilty then?
I'm still gonna have to resume what we just said. Let's try to resolve this.
Your Honor, if I may, his concern was the change in the paperwork from the 18 months to the 12 months. That gave him a little cause for concern.
Why? I could see if it went from 12 to 18, that would give me concern too, but it went from 18 to 12, so lesser charge.
You may inquire my client, Your Honor, if we
Why
do
were you
this-
concerned that it went from 18 to 12?
It sounded like allowing me or whatever, so I don't know what the other 6 months came from, but I was trying to just.
Well, I made a mistake on it. When I told you
That's
18.
why I was trying to lead towards a jury trial, but he told me, man, we can just resolve this and try to continue on with what we have going on instead of trying to testify at that and hear all their side or something. Just go through with what the judge going.
All right, so my concern about this, Mr. Green, is that there has to be a legitimate reason for me to accept your guilty plea, okay? If there isn't, then I can't accept it because that's not what my job is, okay? Because what you said earlier is that you explained to me a situation where the officer came at you first and then you reacted to defend yourself. That's what you told me. So if that's what happened, then you may or may not be guilty of this thing, depending on how the evidence comes out. If that's what you say happened, and I allow you to plead guilty, then that's kind of a charade, because what you're telling me is, on the one hand, yes, I'm guilty of it, but on the other hand, no, I'm not, because he came at me first and I defended myself. You see what I'm saying?
I want to do what my public defender said and just try to resolve all this as it's going on right now. So he just told me.
It's got to be your choice, though. Okay, it's not my choice, it's your choice. If you want to go to trial,
No, just carry on how it's going then.
you may further inquire, Judge.
Okay. Well, it is going to be resolved. It's going to be resolved one way or another. It's either going to be resolved by a plea of guilty or it's going to be resolved by a trial. So it gets resolved. But if you're telling me that you're not guilty of it because of what you told me earlier, then I can't let you plead guilty, because then I'm not doing my job.
Carry on how me and my public defender just had said what we said. We had a little free words, a break. Discuss this.
You said you want a break?
No, we just had one.
I know you had one. Okay, so the question is, Ms. Naroda read or told me what she thinks, if witnesses come in here, the facts would show. And my question to you after that was, is that true or not true? And then you explained to me what happened. Then we took a break. You talked to Mr. Mulkey, and you came back and said you want to do what Mr. Mulkey says, but that really doesn't answer my question, okay? So is what Ms. Naroda said in any sense at all true about what the facts would show if the case went to trial?
I'm doing my own public defender said, man, he said, let's just resolve it and resume how it's going, let's carry on what's going on.
All right, well, that ain't what I asked you, right? I asked you, is in any sense, is what Ms. Naroda said
He don't want me
true?
to testify for a 12 jury trial, and the correctional officer have their side of a say, and then still not agreeing with me. That's a waste of a jury trial.
Okay, well, true, maybe it's not true. I don't know. I've seen stranger things happen. But the problem remains, Mr. Green, that if you tell me you're not guilty of something, then I cannot let you plead guilty to something. You understand that?
I heard you.
I know you heard me. Do you understand that?
No, but I'm trying to carry on with the case, though.
Thank you, Your Honor. After the conversation with my client, I believe that he does desire to maintain and enter a guilty plea to these counts. I explained, again, his right to trial, that the choice must be his and his alone. I can only advise him. And
All right. I think we all get to understanding what's going on here. Guy doesn't want to plead guilty. I don't know why he keeps trying to throw his attorney under the bus. Yeah, kind of a weird tactic, but he's not pleading guilty. Even though he says he's guilty, he's not pleading. So it's not going to happen. Sorry for the weird edits. This court's weird when it comes to when they cut in and cut out. I got as much of this case as I possibly could. So I hope you enjoyed it. I'm going to let it play out. You guys have a great rest of your day. If you haven't done it already, please hit that like button. Until next time, bye.
explain and outline some of the consequences and the procedures with presentation of evidence and so forth. Based on that conversation, I believe that it will be Mr. Green's choice and his choice alone to maintain and continue on with the guilty plea. If for some reason he does not desire to do so, I will be more than happy to provide him with continued excellent legal service as it relates to a trial with the court member of jury of 12 of his peers. Thank you.
All right, Mr. Green? What do you want to tell me?
Right, so he said we was gonna continue on with this guilty plea, and further on about that, try to seek the probation some weeks from now.
Okay, did you get in a scrap with this correction officer in the cell?
He told me to plead guilty to that.
No. Did you get in a fight with this correction officer in the cell?
Right, he told me to plead guilty.
I know. Did you get in a fight with this correction officer in that cell?
They told me to plead guilty.
Okay. I mean, I guess the only thing I can say is we'll see you Monday. If he wants the trial, we'll have a jury trial. If he wants to have a bench trial, we could have a bench trial. But I don't know if you want to talk to him or not talk to him.
I'll talk to him.
Okay.
All right.
Real quick, they don't come back. This is it. So, yeah, I'm guessing they're having their trial. All right, you guys are awesome. Until next time, bye.